We know that consent is an important factor to take into account when talking about rape, but we also need to acknowledge that submission and consent are not the same thing. In cases where a person has consented or submitted to intercourse, there are lower chances of the kind of medical evidence that may come from actively resisting rape. In the absence of such evidence, can the courts conclusively say that the sexual act that was committed was consensual and not assault? Let's hear about a rape conviction appeal before the Supreme Court of India. A man who was convicted of offences under the Indian Penal Code and the Protection of Children from Sexual Offences Act 2012 challenged the Chhattisgarh High Court's decision to uphold his conviction. The defence had argued that the absence of external injuries on the victim, alleged discrepancies in witness statements, and the claim that the prosecution could not establish that the victim was a minor should lead to his acquittal. The challenge to the victim's age was a key point, as it sought to question the applicability of the stringent POCSO Act, but the Apex Court bench found the victim's testimony to be clear and trustworthy. The court stressed that minor inconsistencies are common in such cases and do not automatically render a victim's account unreliable. It reiterated the legal principle that a victim's evidence should be given the same weight as that of an injured witness in other criminal cases. So, the Supreme Court ruled that a conviction for rape can be based on the sole testimony of the victim, even if a medical examination does not reveal external injuries. The court underscored that a credible and consistent account from the victim is of paramount importance and does not require corroboration, particularly when such corroboration might not be available. Head to the comments to share your thoughts on this judgment, and like and share this video so more people learn of this important verdict.